Greetings. I am Oishe Rahman, an LL.B. candidate from University of Dhaka and a young constitutional law enthusiast. Welcome to the third video of our video series, Introduction to the Constitution of Bangladesh. In this video, we will talk about part 2 of the Constitution of Bangladesh. In line with the three generations theory of human rights, Bangladesh divided the human rights into two categories based on their nature and enforceability. The economic, social, and cultural rights are incorporated as fundamental principles of state policy, commonly known as the FPSP in Part 2 of the Constitution, which are not judicially enforceable. The civil and political rights are incorporated in Part 3 of the Constitution as the fundamental rights, which are judicially enforceable. In Part 2, Articles 8 to 25 of the Constitution contain the fundamental principles of state policy. Article 8 identifies the rights written in Part 2 as fundamental principles of state policy and declares them to be judicially unenforceable. Article 8, Clause 2 states that these principles shall be fundamental to the governance of Bangladesh, shall be applied by the state in making of laws, shall be a guide to the interpretation of the Constitution and of other laws of Bangladesh, and shall form the basis of the work of the state and of the citizens, and shall not be judicially enforceable. From Article 9 onwards, we get a number of principles as well as rights that are economic, social, and cultural in nature. Article 9 identifies the basis of Bengali nationalism, which is the unity and solidarity deriving from a language, culture, and the united struggle in the War of Independence. Article 10 establishes a socialist economic system to attain a just and egalitarian society free from exploitation. Article 11 establishes a democratic republic where fundamental human rights and freedoms shall be guaranteed and where people's participation in administration through elected representatives shall be ensured. Article 12 provides for the attainment of secularism by eliminating communalism, granting of favor, abuse of religion, and discrimination. Article 13 states that people shall own and control the means of production and distribution and incorporates three forms of ownership, namely state ownership, cooperative ownership, and private ownership. Article 14 lays down provisions for emancipation of peasants and workers from exploitation. Article 15 lays down the provisions of basic necessities. It provides the fundamental responsibility of the state to attain increase of productive forces and to improve the standard of living of the people by securing to the citizens basic necessities of life, for example, food, clothing, shelter, education, medical care, along with ensuring the right to work, reasonable rest, and social security. Article 16 directs the state to bring radical transformation in the rural areas by promoting agricultural revolution and also to remove disparity in the standards of living between the urban and the rural areas. Article 17 provides for the establishment of a uniform and universal system of education, extending free and compulsory education to children. Article 18 incorporates that it is one of state's primary duties to raise the level of nutrition and improvement of public health, along with taking measures to prevent the consumption of alcohol and other intoxicating substances, except for medical purposes. Article 18A, which was inserted by the 15th Amendment, provides for the state's effort to protect and improve the environment and preserve the natural resources for the present and future citizens. Article 19 provides for the state's efforts to ensure equality of opportunity and equitable distribution of wealth among the citizens. Article 20 incorporates the right of every citizen to be paid according to his or her abilities and prohibited the enjoyment of unearned income. Article 21 states that it is the duty of the citizens to observe the Constitution and the laws, to maintain discipline, to perform public duties, and to protect public property. Article 22 lays down that the judiciary shall be separated from the executive organs of the state. Article 23 incorporates the duty of the state to conserve the cultural tradition of the people and to improve national language, literature, and arts. Article 23A, which was also added by the 15th Amendment, incorporates the duty of the state to protect the unique culture of the tribes, minor races, and ethnic communities. Article 24 provides for the duty of the state to protect the monuments, places of artistic or historic value from damage. And last but not least, Article 25 incorporates the duty of the state to base its international relations on the principles of respect for national sovereignty, non-interference in internal affairs of other countries, peaceful settlement of disputes, and respect for international law, along with the principles of the UN Charter. Although Bangladesh acquired membership of the United Nations in 1974, nonetheless, the International Bill of Rights, comprising the UDHR, ICCPR, and the ICESCR, deeply influenced the drafting of the Constitution of Bangladesh. The ICCPR contains the civil and political rights which are judicially enforceable, whereas the ICESCR contains the economic, social, and cultural rights which are not judicially enforceable, however, are enforceable subject to progressive realization. Following this model, the enforceable civil and political rights are incorporated in Part 3 of the Constitution as fundamental rights, and the unenforceable economic, social, and cultural rights are incorporated in Part 2 of the Constitution as the fundamental principles of state policy. The question as to why these principles are made unenforceable was addressed in the Constituent Assembly debate. It was pointed out in the Constituent Assembly debate that the Constitution, along with laws, also contains certain principles, and these principles indicate the goal of the state to achieve. Dr. Ambedkar, in his speech delivered before the Indian Constituent Assembly, explained the underlying object of incorporating unenforceable directive principles similar to the FPSP of our Constitution. According to him, these principles are the ideals of the Constitution, the hopes and inspirations of the nation to be achieved. The reason for making those principles unenforceable was that when the Constitution came into operation, the country did not have the social and economic infrastructure to make the right to food, clothing, shelter, education, etc. as enforceable. Because if those rights were made enforceable, the citizens could bring actions against the state for non-fulfillment of those rights. The economy of the country was not strong enough to fulfill those rights at that time. Therefore, the social, cultural, and economic rights were incorporated as the goal of the state, which are to be attained. A proposal was raised in the Constituent Assembly to omit the words "shall not be judicially enforceable" from Article 8, but the proposal was rejected by the majority. By the 15th Amendment in 2011, Article 7B was inserted, which provides that the articles of Part 2 shall not be amendable by way of insertion, modification, substitution, repeal, or by any other means. Therefore, Article 7B practically abolished any future possibility of enforcement of the FPSP. Article 7, Clause 2, by declaring the supremacy of the Constitution, states that any law which is inconsistent with the Constitution shall be void to the extent of such inconsistency. Justice Naimuddin Ahmed, in the case of Qudrat-e-Ilahi versus Bangladesh, observed that if any law is in violation of the FPSP, the mischief of Article 7, Clause 2 will be attracted, notwithstanding Article 8, Clause 2, and such law should be struck down as unconstitutional for violating the FPSP. This particular observation of Justice Naimuddin Ahmed was subsequently overruled by the Appellate Division in the same case. Justice Mustafa Kamal stated that it is the law of the Constitution itself that the fundamental principles of state policy are not laws but principles. And since Article 7, Clause 2 addressed the Constitution as the supreme law of the Republic, the FPSP do not come within the ambit of Article 7, Clause 2. Interestingly, although Justice Naimuddin Ahmed in Qudrat-e-Ilahi case sought for negative enforcement of the FPSP, but subsequently in the case of Aftabuddin versus Bangladesh, he deviated from his earlier opinion regarding the enforceability of the FPSP and stated that those principles are not judicially enforceable. Although the FPSP are not judicially enforceable, the court is not only entitled but also under constitutional obligation under Article 8, Clause 2 to apply the FPSP as a guide to interpretation of the Constitution and any other laws of Bangladesh. The court in several occasions distinguished between judicial enforcement and judicial interpretation and applied the FPSP as a guide to interpret several laws. In Kudrat-e-Ilahi case, the court interpreted Articles 59 and 60 in conformity with Articles 9 and 11. In the case of Winifred Ruby versus Bangladesh, the court interpreted the expression public purpose in light of the FPSP. In the case of Salimullah versus Bangladesh, the court held that a certain decision of the government was not in violation of Article 25 and as such used the FPSP as a guide to interpret a government action. In Masdar Hussain case, the court did not implement the FPSP but criticized the state for non-implementation of Article 22, which is one of the fundamental principles of state policy. In the case of NBR versus Advocate Julhash Uddin Ahmed, it was observed that any imposition of extra tax in the name of VAT is contrary to the spirit and principle of Articles 18 and 32 of the Constitution, and as such, the same was struck down as contrary to the Constitution. The court has recognized the duty of the state to respect FPSP and invalidated measures that were in violation of the FPSP. For example, in the case of Muhammad Faizul Islam versus Bangladesh, the High Court Division invalidated the imposition of VAT on English medium schools relying on Articles 15, 17, and 19 of the Constitution. Although the FPSP confer no legal rights and create no legal remedies, these principles are fundamental to the governance of Bangladesh and serve as a tool in interpreting the Constitution and other laws of Bangladesh, as provided by Article 8, Clause 2 of the Constitution. Simultaneously, these principles have been indirectly enforced through judicial activism by our apex court in different cases, because in reality, economic, social, and cultural rights are not less necessary than the civil and political rights. In fact, both categories are interdependent and intertwined for having a life with human dignity. Therefore, until Bangladesh achieves the goal of progressive realization, indirect or negative enforcement of the FPSP through precedents is a commendable action on part of the judiciary in Bangladesh. That would be all in this video. Let's keep promoting human rights, human dignity, equality, justice, and rule of law. Happy World Constitution Day.